ammunition. It is convenient at this stage to deal first with the relevant law. Section 90 of the Firearms Control Act 60 of 2000, the Firearms Act provides, I quote, 90, prohibition of possession of ammunition. No person may possess any ammunition unless he or she, A, holds a license in respect of a firearm capable of discharging that ammunition, B, holds a permit to possess ammunition, C, holds a dealer's license, manufacturer's license, gunsmith license, import, export, or in-transit permit or transporter's permit issued in terms of this act, or D, is otherwise authorized to do so, close quote. Section 121A of the Firearms Act provides as follows, I quote, 1, a person is guilty of an offense if he or she contravenes or fails to comply with any A, provision of this act, close quote. The accused made admissions in terms of Section 220 of the CPA that he did not possess a license to possess the ammunition found at his house, but denied that he contravened the act. Counsel for the defense submitted that possession means there must be the physical detention and an intention to possess at the same time. In other words, there must be, in addition to detentio, animus. In support of this submission, he relied on the matter of S versus Kwanda, 2013, Volume 1, SACR 137, in brackets, SCA. In that matter, the appellant appealed against the dismissal by a high court of an appeal against his conviction on charges of possession of arms and ammunition in contravention of sections 32(1)A and 32(1)E of the Arms and Ammunition Act 75 of 1969. At the time of his arrest, he was the driver of a vehicle that was conveying him and two others to rob a bank. Sitting next to the appellant in the vehicle was another man who carried an AK-47 rifle and ammunition. It was not clear whether the appellant was aware of the firearm in his companion's possession. The companion absconded during the course of the trial. The only question was whether the state had established that the appellant possessed the firearm jointly with his companion. The court held, accepting that the appellant had conspired with his companions to commit robbery, and even aware that some of his co-accused possessed firearms for the purpose of committing the robbery, such knowledge on his part was not sufficient to establish that he had the intention to jointly possess the firearm and ammunition. Accordingly, the conviction on the firearms charges were set aside. From the above, it is clear that the state must prove that the accused had the necessary mental intention, animus, a firearm, or to possess the firearm before there can be a conviction. I'll reread that. From the above, it is clear that the state must prove that the accused had the necessary mental intention, in brackets animus, to possess a firearm or ammunition before there can be a conviction. That it is quite possible to possess a firearm innocently is clear from the fact that if a person who has no license to possess a firearm were to pick up a firearm from where the owner had forgotten it solely with an intention to return it to its owner, it would be an aberration of justice if he were to be convicted of possession of a firearm, as he clearly lacked intention to possess it in the legal sense. In this regard, CS vs. Majigazana, 2012, Volume 2, SACR 107, in brackets SCA. In the present case, counsel for the state made much of the fact that the accused father refused to make an affidavit confirming that the ammunition found in the possession of the accused belonged to him. In my view, that does not assist the state. The accused version is that the ammunition belonged to his father and that he had no intention to possess it. The fact that there is no corroboration for the accused version does not assist at all. Accordingly, what the state needed to do was to introduce evidence to the contrary. It did not do so. The accused version, therefore, remains uncontroverted. The state has failed to prove that the accused had the necessary animus to possess the ammunition. He therefore cannot be found guilty on this count. In conclusion, I'd like to recap on the 4 counts that the accused has been found guilty of. Count 1. In respect of count 1, the allegation was that the accused and the deceased had an argument that the deceased ran and locked herself in the toilet, and that the accused followed her there and fired shots at her through the locked door. 3 shots struck her and she died as a result. Evidence led by the state in respect of this count was purely circumstantial. It was not strong circumstantial evidence. Moreover, the evidence of various witnesses who gave evidence on what they heard, in what sequence, and when, proved to be unreliable. The accused denied the allegations. Notwithstanding that he was an unimpressive witness, the accused gave a version which could reasonably possibly be true. In criminal law, that is all that is required for an acquittal, as the onus to prove the guilt of an accused beyond reasonable doubt rests with the state throughout. The version of the accused was that he fired shots at the toilet door because he thought there was an intruder inside the toilet. The sequence of events, namely the shots, the screams, the shouts of help, the sound of a cricket bat striking against the toilet door, the calls made by various witnesses to security to report screams and or shots are more in line with the version of the accused. Although it is not necessary for the state to prove motive, there is no basis on which this court could make inferences of why the accused would want to kill the deceased. In addition, there is objective evidence in the form of phone records. This too supports the version of the accused. Furthermore, the conduct of the accused shortly after the incident is inconsistent with the conduct of someone who had intention to commit murder. He acted promptly in seeking help soon after the incident. He shouted for help. He called a friend Stander. He called 911. He called security, although he could not speak as he was crying. He prayed to God to save the deceased's life. He was seen trying to resuscitate the deceased, and he pleaded with Dr. Stipp to help, and he was distraught. From the above, it cannot be said that the accused did not entertain a genuine belief that there was an intruder in the toilet who posed a threat to him. Therefore, he could not be found guilty of murder, dolus directus. This court has already found that the accused cannot be guilty of murder dolus eventualis either, on the basis that from his belief and his conduct, it could not be said that he foresaw that either the deceased or anyone else for that matter might be killed when he fired the shots at the toilet door. It also cannot be said that he accepted the possibility or that possibility into the bargain. I might just add that in respect of the first leg of the test in dolus eventualis, Birchall and Hunt, principles of general principles of criminal law states the following on page 371. The courts have warned against any tendency to draw the inference of subjective foresight too easily. For example, in S. v. Bradshaw, 1977, volume 1, ph, H60, capital A in brackets, Vessels J.A. stated, I quote, "The court should guard against proceeding too readily from, single quote, ought to have foreseen, close quote, to, open single quote, must have foreseen, close single quote, and thence to, open single quote, by necessary inference, in fact, foresaw, close quote." The possible consequences of the conduct being inquired into. The several thought processes attributed to an accused must be established beyond any reasonable doubt, having due regard to the particular circumstances which attended the conduct being inquired into. Close quote. And in S. v. Sekhwatla, 1967, volume 4, SA 566, capital A in brackets, Holmes J.A. expressed the degree of proof in the following terms. I quote, "Subjective foresight, like any other factual issue, may be proved by inference to constitute proof beyond reasonable doubt. The inference must be the only one which can reasonably be drawn. It cannot be drawn it cannot be so drawn if there is a reasonable possibility that subjectively the accused did not foresee, even if he ought reasonably to have done so, and even if he probably did do so," close quote. Evidential material before this court, however, show that the accused acted negligently when he fired shots into the toilet door, knowing that there was someone behind the door and that there was very little room in which to maneuver. A reasonable person, therefore, in the position of the accused with similar disability, would have foreseen that possibility that whoever was behind the door might be killed by the shots, and would have taken steps to avoid the consequences, and the accused in this matter failed to take those consequences. I'm dealing with count 2 in a summary form. In this count, the state alleged that in September 2012, while driving in a vehicle with other passengers on a public road, the accused unlawfully discharged a firearm without good reason to do so by firing a shot with a 9mm pistol through the open sunroof. The alternative count is that the accused discharged a firearm, to wit, his 9mm pistol, with regard for the other passengers, with disregard for the other passengers in the car and or in the vicinity. On this count, the state failed to prove the guilt of the accused beyond reasonable doubt. In respect of count 3, the state alleged that in January 2013 at Church's restaurant, a public place, the accused unlawfully discharged a firearm, to wit, a Glock 27 pistol, without any good reasons to do so. The first alternative is that at the same place on the same day, the accused negligently used a firearm, to wit, a Glock 27 pistol, and caused damage to the floor of the restaurant. The second alternative to this count is that at the same place and the same day, the accused discharged a firearm, to wit, a Glock pistol, at a table in the restaurant among other patrons in a manner likely to endanger the safety of the people at his table and or other patrons and the property of the restaurant. The accused had, in discharging the firearm mentioned, shown a reckless disregard for the safety of the patrons of the property of the restaurant. Count 4, the allegation was that on about 16 February 2013, at or near 286 Bush Willow Street, Silverwoods, Country Estate, Silver Lakes, in Pretoria, the accused was unlawfully in possession of ammunition, to wit 38.38 rounds, without being the holder of a license capable of discharging that ammunition, a permit to possess ammunition, a dealer's license, gunsmith license, import, export, or in transit permit, or transporter's permit issued in terms of the Firearm Control Act number 60 of 2000, or is otherwise authorized to do so. In respect of this count, the state failed to prove beyond reasonable doubt all the elements of the charge. Mr. Pistorius, please stand up. Having regard to the totality of this evidence in this matter, the unanimous decision of this court is the following. 1. On count 1, murder read with section 51(1) of the Criminal Law Amendment Act 105 of 1997, the accused is found not guilty and is discharged. Instead, he is found guilty of culpable homicide. On count 2, contravention of section 120, 127 of the Firearms Control Act, number 60 of 2000, and the alternative count, that is contravention of section 120, 3B of the same act, the accused is found not guilty and discharged. On count 3, contravention of section 120, subsection 7, alternatively count 120, subsection 3A, and further alternatively section 120, subsection 3B of the Firearms Control Act, number 60 of 2000, the accused is found guilty of the second alternative, that is the contravention of section 120, 3B. On count 4, contravention of section 90 of the Firearms Control Act, number 60 of 2000, the accused is found not guilty and discharged. You may take a seat, Mr. Pistorius.
Please go to, we have no previous convictions.
Thank you.